Okay, we're going to go ahead and get started. Good evening, everyone, and welcome. I'm Aisha Solomon, your Alachua County Property Appraiser, and I'm so pleased to have you all here for our 10th Probate and Estate Planning Summit. Before we get started, please be aware that tonight's event is being photographed, recorded, and live streamed so that we can extend this important information beyond those who are gathered with us this evening. First of all, I would like to share our sincere thanks to Greater Bethel AME Church for opening its doors and providing us with such a welcoming space for us today. I also appreciate Reverend Rawls and his lovely wife, Honorable Michonne Rawls. Thank you for your hospitality. I also would like to give a special thank you to Monica Range. She's our keynote speaker and our moderator for this evening. And I want to say a little bit about how I came in contact with Miss Monica Range. I was at an Heirs boot camp in Atlanta, and I have never seen anybody explain such a complicated process so simply, to the point where I just knew that what we were doing in Alachua County, I knew that I had to get a hold of her so that you all can experience what we experienced. It was superb. You're in for a treat, that's all I'm trying to say. So it came full circle too. I realized tonight that these are her roots. She actually came to this church when she was in law school, and Reverend Rawls and what they're doing in this community, I knew that this is what made our 10th Summit so special, is how they're connected in our community and what they're doing here in Alachua County, that I wanted to bring it back here, but I didn't realize that this is the church that she came in, and then I was connected with Reverend Rawls, and it all came full circle, so I just feel like it was divine. So I'm pleased to see how the stars are aligning and everything is working out just the way it's supposed to be. I also want to thank our community partners, presenters, our legal professionals, and everyone who worked behind the scenes to make this event possible. We have judges here, we have our mayor here, we have our mayor from Hawthorne. I say mayor of Gainesville because we're in Gainesville, but we also have the mayor of Hawthorne, we have our judges, and I just appreciate all of you for joining us this evening. Commissioners and all, so thank you all. Most importantly, I would like to thank each and every one of you here tonight. We know that the conversation about heirs, probate, and estate planning is not always easy. Sometimes we put them off simply because we think we have time, or simply because we don't know where to begin. Tonight, you're going to hear from professionals who work with these issues every day. My hope is that you not only leave here better informed, but better prepared to take the next step for you, for yourself and your family. So this is step one. Step one is acknowledging or educating yourself about the issue. Step two is the process, starting with our workshop. So we have a workshop that there's some hands-on activities that you can do to better prepare yourself for an attorney. And then step three is to select an attorney, and through our partnership with our local attorneys, we do have a legal network, and it might be in your bag or your folder that you can make those connections as soon as you finish your workshop, or even after you leave here. And you'll hear more about that later this evening. Also, I also want to mention while we are at it, silence your phones, please. And again, thank you for being here. We'll go ahead and get started. Yes, ma'am.
Good evening, Alachua County. I am so excited to be here with you once again for the 10th Probate and Estate Planning Summit. I want to thank Aisha for that very warm welcome. As you said, I am truly welcome to Gainesville, which has been like a second home to me since I was a law student. And I am especially excited tonight to be here at Greater Bethel AME Church, which, as Aisha said, was the church where I fellowshipped when I was a law student at the University of Florida. So let me tell you that I owe them a big gratitude, because not only did they feed me spiritually, they fed me physically as a student when I needed some free meals. So Reverend Rawls, thank you for the work that you and First Lady Rawls continue to do to bless college students while they're here in the city of Gainesville. I also want to give a big thanks to Ms. Solomon and her team for the amazing work that they are doing to create this summit. And we're at the 10th summit, right, Aisha? So that is a milestone for this community, because as I have traveled over the country working with heirs property owners and doing education and outreach programs, I've not seen a program that can parallel what you have here in Alachua County. So let's give a big round of applause to Ms. Solomon and her team. This is truly an example of a great collaboration between a public-private model where the community is benefiting from all of the resources that you have available here in Alachua County. And so I'm so excited about this being the 10th summit for the residents of Alachua County. Now, I want to do a quick temperature check and see who's in the room. If you own property here in Alachua County, I want you to stand up. If you're the only person on the deed for that property that you own here in Alachua County, stand up really quickly. Wonderful, wonderful. Now, if you are a property owner and you have inherited property from a family member here in Alachua County, would you stand up? Awesome. Wonderful. You may be seated. Well, let me just commend you for taking the time this evening to join us for this session on estate planning and probate. I'm Monica Range, and I am passionate about heirs property. It is my calling in life, and I have spent the last 25 years working with thousands of families, helping them to understand how to resolve heirs property issues. And I'm going to tell you a little bit more about my story. But tonight, as we walked into this beautiful place of worship, one of the Bible verses that I thought about was Proverbs 13:22, which says that a good man leaves an inheritance to his children's children. And that's really what this summit is all about today. It's really thinking about what you want to leave to your children's children. Now, how many of you brought a phone in here with you tonight? Take that phone out for me just a second. Now, I bet that all of you have on that phone at least one photo, don't you? Turn to your photographs for just a second. And I want you to just slide through some of those photographs, because I need you to get a good picture of what your legacy looks like. Because really, that's the why tonight. When we think about those people that we consider to be our loved ones, our family, people that we want to leave a legacy for. The property we own in Alachua County is going to be one of those assets we leave to our family. And for me, everything starts with legacy. We think about grandmother's home and the memories we had in grandmother's house, and how when grandmother dies and does not leave a will, that property becomes heirs' property. It is passed down through generations, and grandmother's name remains on that property. And while the memories go on, I think about grandmother's house at my grandmother, and I think about the holidays there, the cakes baking, the laughter, the hard work, the births, the celebrations, the legacy left in that home. Now imagine when grandmother dies without a will or without a plan, that home no longer clearly belongs to one individual. In fact, it may be in the hands of family members, 5, 10, 15 family members. And so what we want to talk about today, we want to lay a foundation for our summit tonight, because heirs property is really the root of the problem. Heirs property is often the reason why many people don't do any estate planning, or they don't take the steps necessary to open up a probate. And what you're going to get tonight is a full session of strategy and information to help you jumpstart your own probate for a family member, or help you jumpstart your estate planning journey. Now, as I told you, my journey here began right here in Gainesville as a student at the University of Florida. And what I realized at the University of Florida during my first year of law school was that I could do a public interest internship with an organization called the Federation of Southern Cooperatives. In doing that internship, I had an opportunity to work with heirs property owners. And I learned that this was a big problem for many families. And they were losing property at an alarming rate across the South. And so during that internship, I had an opportunity to help them take steps to resolve their heirs property. But the bigger thing for me, the bigger takeaway, was that I had found my life's work. I had found my calling. And so when I graduated from law school, that organization called me back and said, hey, we've got a job open, and we would like to consider hiring you for that position. And so I started working with heirs property, and 25 years later, I've had the opportunity to work with thousands of families. And this work was so much bigger than I ever thought it would be. I ended up founding the first and the largest still today National Heirs Property Conference, where practitioners, attorneys, and heirs property owners are able to come together and share resources about best practices for resolving their heirs property. So, Ms. Solomon, what is so amazing about what your team has done is you've created a one-stop shop for the Gainesville community to come out and hear about how to resolve heirs property, jumpstart your estate planning, or get probate resources that you may need to open a probate. So when I think about this summit, I often think about building a toolkit. So tonight you came looking for answers to specific questions. And we're going to answer those questions for you several ways. This keynote is just the start, but we've got a program packed full of nuggets for you to take back information. And we're going to do the keynote. Then we're going to start with an attorney panel. And that panel, we've gathered some of Gainesville's most distinguished attorneys who work in probate and estate planning matters. So we're excited about that. And then after that, we're going to have presentations from the Alachua County Property Appraiser's office, presentations from our tax collector's office, and then we're going to hear from Three Rivers Legal Services. All of this is designed to help you build a toolkit. Because one of the things I know is that in heirs property, you've got to start out with the right team, and you've got to tap into resources which will help you to do work that is really hard work. I like to live by an African proverb, and that proverb says that if you want to go fast, go alone. But if you want to go far, go together. And so the goal tonight is simply to help you develop your very own toolkit so that you can go far and fast. Now, when we think of a toolkit, I brought a few things because I think oftentimes these are some of the common tools I use around the house. And one of the things that helps to understand what heirs property really is, I like to say your measuring tape is a good example of a tool that you want to have in your toolkit. Well, with heirs property and family land ownership, oftentimes the tape measure helps you to kind of measure what's accurate about the situation. Sometimes when you're dealing with your family, especially, there may be some misconception, perceptions about the situation that are not accurate. So sometimes it's very important to have a measuring tape in your toolkit. Now, another tool that I like to use at home is called the leveler. How many of you could use a leveler in your family? I heard one attorney say that family is a lot like fudge, sweet and full of nuts. Some of you may have some of those family members in your family. So when you're trying to think about heirs property, imagine owning property with 5, 10 family members and trying to make a decision about that property. Some of us can't even decide what to have for dinner, much less what to do with grandmother's house that we now find ourselves in ownership of. Now here's a tool that a lot of my clients love, the hammer. The hammer is a tool that everybody wants to carry. And what we find is when you have only a hammer, everything looks like a nail. And the problem with the hammer is it tends to bring about conflict in families. We can't agree. One family member wants to sell the house. One family wants to live in the house. One family member just wants to get some cash out of the house. So the hammer becomes a source of conflict in families. And so I am a trained mediator, and I tell people that I didn't realize as an attorney, I probably should have gotten a degree also in psychology, because much of what I do is trying to figure out human psychology and helping people work through conflict. But if I get to a table and everybody has a hammer, that's probably not going to be a case that we can get resolved, because hammers don't solve conflicts. It just kind of creates more wounds for everybody. Now, when you hear from, get the information that you're going to get this evening, you're going to realize that you will need a diverse toolkit. You're going to be able to access resources that exist here in the Gainesville community, whether it's through working through private attorneys, working with public attorneys, or working with some of the offices you're going to hear from today. Now, over this initiative, as Aisha said, this is not just a one and done initiative tonight. This will be a work in progress where you will have the opportunity to be up close and personal, working with all of the partners of the initiative over the next year. Now, what are our key takeaways? Our key takeaways for tonight: 1, we want you to understand what heirs property is. 2, understand what fractional ownership is and how it develops over generations. 3, identify challenges created by divided ownership. 4, explore the economic consequences of heirs property. And 5, gain strategies to protect land and preserve family wealth. Now let's talk about the elephant in the room for just a moment, because what I've learned over the last 25 years working with families is there's always an elephant in the room. And for Alachua County, that elephant is the fact that you're dealing with a $550 million problem. Now, Ms. Solomon and her team have worked closely with data scientists to do the research and determine that right here in Alachua County, there are 1,600 properties already classified as heirs property. That means the person who owned that property has died, yet their name is still on the deed of record. So some of you may be sitting here, you're saying, hey, that's me. I'm one of those properties where someone has already died and we haven't taken any steps to open a probate in this case. Some of you may be in the other category, which is you own property here in Alachua County, but you are the sole owner of that property. And no one else, you don't have an estate plan. You don't have a will. So at your death, what may happen is that property will become heirs property. Now, this creates a situation where Alachua County has about 3% of all of its properties in heirs property status. Now, why is that something we should be concerned about tonight? Because what we know is that when heirs property happens, it is a symptom of a larger problem within the community. When families are losing property, that's families losing housing. And when families are losing housing, those are families losing economic opportunity. And when families are losing economic opportunity, they are also losing hope. And so what if we imagined a community where no family is left behind and they have the resources they need to initiate a probate? They have the resources they need to get a will in their community at a fair price. And so this is the why for tonight. This is why this type of summit is so important to this community. This summit is designed to put us all on the right path, to connect you with the resources that you need to protect your family property and to protect your family legacy. Now let me just recap. What is heirs property? We said it is land passed down from a family member who has passed without a will or a formal estate plan. It is typically owned jointly by multiple family members who inherit as what we call tenants in common. Now that phrase, tenants in common, you're going to hear when we do the attorney panel in just a moment. We'll probably use that phrase because what attorneys refer to as a tenant in common is everybody owns this property. All right, grandmother died, there was some property, now 10 family members own it as tenants in common. That means that I like to refer to that as property that's owned by everyone but no one. Because the law says that if you own the property as a tenant in common, you have the right to use that property in any way that, all of the owners have the right to use that property. And so I'm going to talk a little bit later about some of the economic consequences of a tenancy in common property ownership where the ownership interest has not been formalized. So in other words, you don't have proof that you actually own that property. And not having proof of ownership is another legal term I'm going to throw out there. That title is considered clouded, not clear, unstable. So your property ownership is locked and tied up because multiple people own that property, but no one can actually show proof that they actually own it. So let's go back to the title of our seminar tonight. We said we want to unlock economic opportunity and potential. And so the only way to unlock the financial potential of that property is to get it out of heirs property status. Now, every heir owns what we call a fractional ownership or share of that property. No single owner has clear title or full decision-making authority over that property. And so when that property is tied up and all of the owners just simply have fractional title, it's a mess. It's a mess. And what I have seen as an attorney is families will allow that property to continue to pass down through generations. And so there are times when I've worked with families and there are 25, 50, 75 heirs who claim an interest in one piece of property. It's a mess. So now we're going to make this a little bit fun and interactive tonight. I'm going to need about 8 volunteers. If you can volunteer, come on down. I want to do just a quick demonstration with you tonight. So if you can volunteer, I need about 8 volunteers to come right over to this side for me. And we're going to talk a little bit about what fractional ownership is and how it happens. So if you would just come line up here for me. We need about 8 people just to join us. Thank you so much. Come on down. Come on down. All right. Thank you. All right, Mr. Tim, we're going to allow you to be in our example. We're going to use John for our example. Now, John is a widower here in Alachua County. All right? And we're going to show you how fractional ownership develops over time and how it becomes a really unmanageable problem, one that really needs a solution, because the family over time is holding a bag of money, and that bag of money has a hole in the bottom. So as you allow fractional ownership to develop over many generations, it's like money continuing to fall out the bottom of that bag. So Tim, if you will hold it, we're going to pretend that you are John today, and you have 4 kids. So I need 4 people just to pop in front of him here, grab the string, because in heirs property, the property passes to each generation, and we're just going to keep passing that string along. John, if you'll keep putting more of that string out. Okay, John is widower. He has 4 children. Now, when John dies, how much does each of these children own? All right, I got a great math group here tonight. Somebody said it. Somebody said it. 1/4 interest is owned by each of the children. Now, that's pretty clean. The math is pretty easy. But let's suppose, for example, that this gentleman has 2 children. So I need 2 more children to come on out, and you're going to stand in front of your dad right here. All right, you'll just come right here, and you are one of the 2 children he has. Okay, all right, I may need 2 more volunteers. All right, come on down. Thank you so much. Now, this child of John's has just 1 child. So let me have him come right on over here. You're going to stand in front of your parent. Okay? You're going to stand right here on the end, and you'll grab a piece of the string. And then this child also has 2 children. So if I get you 2 come over, perfectly, this is your parent. So you need to grab part of the string there. There you go. Okay, does everybody see how the generations are developing? Okay, so let's suppose for just a moment that John's son right here dies. Now, his children will inherit what from their father? Okay, so how much do each of them own? I heard it. 1/8. Okay, so let's go through, and when I point to you, I want to make sure we've got all of the percentages correct. How much does he own currently? How much? No, he doesn't own anything because his mother is still living. I caught you. How much do these two own? 1/8. He's dead. Your dad is dead. Okay? How much does John's daughter own? She still owns a 1/4 share. So she owns 25%. And how much do the two on the end own? Their father is still alive, so they don't own anything. All right, you guys are doing great. Okay, so when we get a case come in our office, right, Adam? The first thing that we need to do is figure out what is going on with that family. We need to develop a family tree so that we can figure out what percentage of ownerships there are. But it's not just that. Oftentimes, we're dealing with families who haven't done any probating at all. So then we ask the question, who's dead in this family? Who's dead on this family tree? Because in order for us to clear title, we're going to have to go back and do probates for every person who has died in the family. You understand how this gets complicated pretty quickly, right? But that's not the only thing that's going on, because this little guy right here is starting to cause problems. What's happened is an investor has reached out to him, and the investor says, hey, what's your name?
Max.
Max. He says, Max, you own some property that your grandfather John had, and you're going to be an heir to that property. Would you sell us that property for $5,000? Not the property, but your interest. Max says no. He's already got this. But now suppose Max lives in Chicago. He doesn't plan to come back to Gainesville. So Max is going, wow, I can get $5,000. I have no idea what grandfather's property looked like, and I never stayed there, so I'm disinterested in grandfather's property. So Max is now being approached by investors who want to buy his interest once he inherits from his mother. What happens if one heir sells their interest to an outside person? That person becomes a tenant in common with the entire family. Now, here in the state of Florida, watch this. Here in the state of Florida, if a person owns any amount of interest, they can force a sale of the entire property through what's called a partition sale. Many people don't know that. And this is why it's so dangerous to keep your property tangled and tied up with all of these heirs. Because one person could sell their interest to someone who could force a sale of the entire property through what's called a partition sale. So that's one of the vulnerabilities, but that's not your only vulnerability when you have heirs property. Well, come to find out, this heir has been paying taxes. And she's the only heir that's been paying taxes on the property. The rest of them are just freeloading. She's paying the property taxes, she's doing the maintenance, she's cutting the grass at the property. The rest of them are doing nothing. But she's getting tired of that. And she's threatening not to pay the taxes this year. What happens if she stopped paying the taxes? If she doesn't pay the taxes, that land could be lost, all of it, to a tax deed through a tax sale. And you're going to hear the tax collector's office talk about what happens when there are properties where taxes are not paid. But that's a vulnerability. So one of the things that tenants in common have to do is they have to come up with a management structure for this property where everybody is kind of contributing something. Because what I've seen in my experience is that usually one family member is going to get burnt out. And they're going to say, you know what, I'm not going to pay anymore. Or that one family member that's paying the taxes may die, and then the entire property could be lost. And then you've got the relative on the end. This lady, she's like, that's my grandfather's property. I can live on it for free. My boyfriend and I are going to move in. we're going to stay on that property for free. Now, is she right? Yeah. She can live on the property because remember I said they're all tenants in common. They have all the same rights of access to that property, but family members can certainly come up with an agreement, a tenancy in common agreement, which says, you know what, if you're going to live on the property, you need to pay some rent. That rent should be divided based on your pro rata share of ownership. You get something from that rent each month. But what happens here often is that heirs are just tangled and tied up together. And they kind of bury their heads in the sand. And they do nothing. So you allow a generation, another generation, and another generation, and another generation to come, and they all own that one piece of property together. And so this is the problem of heirs property. You guys have been amazing. Give them a big round of applause. Thank you so much. So that's the problem of fractional ownership. It is the idea that all of these owners are tied together. And what we have seen is the consequences of tangled, tied, unclear title, where essentially those owners aren't able to leverage that home as an economic asset. You know, if you own your home outright, you can walk into a bank and say, hey, I want to do a home loan or credit on this asset, and the bank will say, great. We see you own it, great. But if you're an heirs property owner, you don't have the ability to leverage the heirs property because in most cases, title, which is unclear, will prevent you from using that property as collateral. And many years ago when I started working in this area, it was right about the time of Hurricane Katrina in New Orleans. And what we learned then was that many of those families in New Orleans couldn't even get FEMA benefits because they could not show proof of title. And so that was something that prevented many of those families from being able to build back those homes in New Orleans. Well, we live here in Florida, so we're very disaster prone. And I think if we don't care about anything else, we have to say, wow, I need to clear this heirs property up because if something were to happen, I wouldn't be able to access even some of the government programs without being able to show clear title on that property. So these are just some of the difficulties of ownership when you have heirs property status. Not being able to get loans, not being able to access government programs, not being able to maintain even homestead status. Because guess what? In my example, when John dies, that family is probably going to lose homestead status, which means the taxes will go up. And the tax collector can talk a little bit more about that during her presentation. During his presentation, I think we've got someone, okay? But these are just consequences where we have the ability to head off some of this by making decisions right here today and by looking at the tools that are in front of us to figure out a path forward with our families. So let me close because I want to move into our panel discussion with our attorneys. What I want to leave you with today is we have an opportunity to keep assets in our families which will build wealth, community stability, and economic opportunity. I urge you not to let your property here in Alachua County become someone else's asset. We can't wait to fix the problem. We have to make 2026 the year that we're going to commit and activate to working through these problems with our family and building a stronger financial future. One of the mottos that I live by, and I almost say it every day, is I am only one, but I am one. I can't do everything, but I can do something. And by the grace of God, I will do something. Welcome to Summit 10. Let's move now into our distinguished panel of attorneys. And what we're going to do during our panel is really give you insight into what attorneys deal with on a daily basis working with heirs, property owners, and others on probate and estate planning issues, because I know many of you came with those burning questions, questions that challenge your family and challenge you. And so we'd like for you to hear from our panel of experts tonight. And I want to just go ahead and introduce our panelists and ask them to join me on the stage. Our first panelist is attorney Adam Towers. Adam is celebrating his 25th anniversary as an attorney and has been a resident of Alachua County for the past 20 years. His practice focuses heavily on real property disputes, probate and trust administration, and estate planning. He is also frequently retained to protect rights to inherited property, clear title to real property, and resolve family disputes involving real estate. That makes Adam particularly well positioned to help us understand what happens when family property has already become complicated. Adam, we are certainly looking forward to your perspective on heirs property and the intersection between probate, title, and family conflicts. Our next attorney panelist is Ernest A. Sellers Jr. Is Mr. Sellers here? All right, I don't see him in the panel, so I'm going to ask Jennifer Meiselman Titus to join us. Thank you, Attorney Titus. Jennifer has more than 20 years of legal experience and has an advanced LLM in taxation from the University of Florida. Her practice focuses on estate planning, wills, trust, probate, and guardianship. What particularly distinguishes Jennifer's approach is her emphasis on the human side of estate planning. She is known for her empathetic and caring approach and believes that families benefit from education and thoughtful planning for death and incapacity. Jennifer, we are glad to have you on board our panel for your technical expertise and your perspective on helping families and having those difficult conversations before they become a legal crisis. So we're going to transition to our panel at this time, and my job as the panel moderator is to make sure I keep us on track in terms of time, but also to talk through some of those questions which many of our audience members may have, thank you so much, about estate planning and probate, and really hear about your experiences. Adam, you and I were talking a little bit before the session started, and you have really had the opportunity to represent some unique cases, and you were telling me about some of your cases that go back very far in history and your experiences with some of those cases. So since it's just the three of us, I'm going to allow you all to just give a brief opening statement about some of your experiences before we dive into some questions.
Sure. Thank you for everyone being here today, and appreciate Monica's opening remarks. The example that she gave with those individuals, that's real life. That's things that we deal with every day here in Alachua County. The one particular case that I think is probably the most complex is one that I had a 93-year-old beautiful woman come in to meet with me, Miss Ellen Buchanan Jordan. This was back in 2015. She was 93 at the time. She just passed 2 years ago at 102, 103. Beautiful shirts too. She came in to me and said, "I'm the last survivor of my parents' 6 children, and we want to do something with the property." And I said, "Okay, well, let's take a look at the last deed of record." She says, "Well, it's in the name of my mom, because it says Louise Buchanan, or heirs of Louise Buchanan, who are the property appraiser and tax collector's notice. So we said, okay, well, let's go to the records. Let's find the last deed of record. This was 70 acres that she mentioned. Well, we looked back in the records, there was 30 acres. And I said, well, this can't be right, because obviously it appears 70 acres under the property appraiser's map. But the 30 acres that we found was from her dad in 1920. And so after we did more and more digging, found out there was an additional 40 acres that was acquired by her grandfather in the 1870s that was part of the Hell Homestead plantation at that time. Then we had to track down, okay, well, that last deed of record is dating back to that point. Now we have to figure out the heirs. And you can imagine over the generations of a 93-year-old woman, of the last survivor, how many individuals we had to track down. We went through family Bibles. We went to the church cemeteries. We went through the Freedmen's Bureau Act to find out. We went through census records. And lo and behold, we eventually prepared a family tree that covered all the generations and found these fractional owners. And I could talk more about the fractional owners later. But this is a very real thing that we have to deal with. So the longer you kick the can down the curb, the worse it will be, and the less real viable options that you have at that point. So this is a very real thing that we deal with. Yeah.
No, I'm glad you brought that up, Adam, because, oftentimes people don't even know where to start when it comes to trying to locate heirs after so many years. And so I love the fact that you pointed out some of those places where you can start to track who the heirs are and develop your own family tree to get some of this work started. Jennifer.
So, can you guys hear me? I hate microphones. Okay, good. So, my name is Jennifer, and I'm so grateful to be here. I am very, very passionate about educating people, because I think that the more you know, once you know better, you do better. And heirs property is close to my heart because I've seen so many good people have houses that their grandparents built, that have been in their families, that they enjoy, that they love, that they have memories of. And I've had clients that then the storms have come through and nobody has the ability to get the FEMA aid because there's never been a probate. And so then there's a rush, and we're still trying to find people to sign consents. We're still trying to find all of the people we need to so that we can get titles, so that we can get the aid that's needed. And I see heirs property as family legacies. I see it as, this is your story. Your grandfather built this house. He would want his great-great-grandchildren to have this house. So it's important to have, and it's the foundation of building wealth. And once you own a home, so many things are open to you. And so I think it's so important to resolve heirs property issues, because I think, like what we had mentioned earlier, is that when people have resources, they can do a probate, and it's not a huge deal. It's a pain, but it's not the end of the world. When people don't have resources and this house is all they have, then it's a huge step to be able to take. And it's hard to get the money together to pay filing fees. It's hard to get the money together to do an appraisal. It's hard to get the money together to do things. And so I see it as my privilege to be able to help get through this. And then once we've done that, then I think it's super important to make sure we don't have that problem happen again. And that's where the estate planning piece comes in, because it was such a pain to go through it without having the documents. Let's make sure the documents are there for the next generation so that we don't have to do that. And so I see that as our ounce of prevention.
So this idea that, we have an opportunity to prevent versus cure. And I'm curious, Adam, from your legal perspective, what are some of the biggest challenges that we want to prevent in terms of heirs property?
Well, I mean, I think as far as the prevention, it's really clearing the title. I mean, that's really what it comes down to. And when an individual dies, there is a last deed of record, and that's who is the owner of that property. Well, for many of the reasons that you'd mentioned earlier, if you don't take care of that, you could lose your homestead tax exemption. So now you're paying more, even if you have family members living on it, because the title is not cleared at that point. You will not be able to get a loan. You'd mentioned one of the things you mentioned I thought was hilarious because it was in the story or the example that I was sharing, where you had a boyfriend move in to the property. Well, what happens when, in our case, it was the girlfriend, the live-in girlfriend of one of the great-grandchildren who had no ownership interest in it? And what do you do when you have to get rid of that person, right? Well, now you start an eviction action, and if they're smart, or if they go to Three Rivers, or they go to someone that's going to tell them, they're going to say, well, this person doesn't have title. How are they going to get you removed from this property? So those are problems, real life issues that come about if you don't take care of it. So, clearing those issues up is going to be a little bit of a pain, a little bit of a headache, and a little bit of cost. But the further you wait, you're just simply delaying the issue, kicking the can down the curb, and you're just pushing that problem onto future generations, which exacerbates the problem.
Now, suppose we have a situation where one family member has been paying the taxes for 20 years and another family member has been living on the property, tax-free. How do these situations create unique legal challenges? And I think a little bit of what you spoke about kind of speaks to this, but the question that I often get from many heirs is, what action can I take against the person who may be occupying the property?
Perfect. And the perfect legal answer is, it depends, right? There's lots of different options that you have here. The most cost-effective option is you get together with all the family members and you say, okay, look, we're all joint owners of this property in different fractions, all right? Let's create a joint account. Let's put the resources in it, and then that pays the taxes, that pays the maintenance, that pays the insurance, that pays the upkeep, whatever needs to be done. But the reality is, most families, unless yours are all perfect, most families don't do that. You have one person that pays it, right? Mm-hmm. You have another person that's living on it, and like, hey, they're paying the taxes. I'm living here rent-free. What a country, But also, when you're in that situation, the person who doesn't have an ownership interest in it, or they haven't put it in title and they're not paying anything, well, then they're not taking care of it either. And then it's deferred maintenance. And then you're exacerbating the problems because you're not putting money into it to preserve that asset as well. So, again, lots of different options you have. You can come to a family agreement. That's certainly one option. If you can't come to an agreement regarding what to do with the property, technically everybody who has a percentage ownership interest in that property has the obligation under the law to contribute their percentage. So if your taxes are $2,000 and you're a 5% owner of that property, you technically are required to pay 5%. The reality is that doesn't happen. You have one person that's paying for it because they are duty bound by grandma, that they said that they'd preserve and protect that property to their own expense, right, and their own detriment. They're advancing those properties. Now, if you can't come to an agreement and get the other person to reimburse you, there are a couple different mechanisms in court. One that's called a contribution action, where you're just filing suit to force the other person to get a judgment basically for that amount. And then if they don't pay it, you can put a lien on the property, and it's a whole another hassle. Or the other option that you mentioned before is a partition suit, where as part of that partition suit, you can say, Your Honor, we can't agree on what to do with this property. We want it sold. And also, because I paid for all the taxes for those last 10 years, and I paid for the insurance, and I paid for the maintenance, and I paid for the upkeep, and I paid for the attorney to file the suit, to clear the title, to clear the probates, and do all the things that are necessary, I want to be reimbursed a percentage share from everybody as part of that process. And so there is a way of getting reimbursed those expenses, but it's a longer term. It involves, an attorney, it involves a court system. So if you can avoid that, that's the perfect scenario.
And Jennifer, I want to bring you in on that point, because I think, oftentimes we look at the legalistic side of this problem, and we think about the steps. But there's a very human side to heirs property work, and I think it challenges us as legal practitioners to really balance the human emotion. And so what strategies, or maybe give us an example of how you have seen some of the other side of this play out and how you're able to manage families working through this process.
It's hard. Family relationships are the hardest because once you file suit against your family member, what happens? Your relationship has disintegrated to the point where you have to go to court. And so I always try to counsel people to say, look, if you love your family, let's figure out a way to make this work without involving the courts. Because I promise you, once the court's involved, everybody's going to be unhappy. Sorry, Judge Ross. But that's how it works. And so, and there's a lot of hurt feelings that come up. And so there's a lot of family emotions, mom loved you more, or you got the pony and I didn't. There's a lot of weird emotions that happen. I have a case right now where there was a stepfather and a half-brother who moved out of state to Maryland with the mother. My client is the child of the mother, and there's property in Madison County. And the stepfather, did probate in Maryland 20 years ago, didn't do probate for the property in Florida, but has had a renter on that property the whole time. And now my client is like, wait a second, I'm entitled to my share of this property. And he said, my mom said she wanted X, Y, Z to happen. But mom didn't write it down. And mom didn't record it. And nobody is enforcing what mama said. Now we're looking at what does the law say. And so the law says, well, there's a surviving spouse. And now there's also 2 children, one of whom is not the biological child of the surviving spouse. So now you have all of these feelings because even if when my client gets his share, his half-brother and stepfather are going to end up with a larger share. And so there's a lot of hurt feelings there because that wasn't his mother's intention. And so there's feelings there. And so to manage those feelings is difficult. This is probably one of my most difficult clients, and I have a lot of compassion for him, but boy, does he call and text and email me 3 times a day, every day. And I'm like, it's a process. It can't happen right now. We have to wait for the court, and the court can't decide immediately. Like, they have to review things, and then they'll sign. So it's hard. But it's a matter of the family relationship broke down a lot sooner than the paperwork not being completed.
Adam, let me get your perspective on that.
Yeah, especially for these larger cases that that oftentimes find their way to me. We try to schedule family meetings with as many people as we can to bring them all together. And one of the first things that I tell them at the very beginning is, the more you fight, the more the lawyer becomes a beneficiary of your grandfather's estate, right? That's the reality of it. So if we can come together and resolve some of these disputes as much as we can, that's going to be much cheaper. For instance, avoiding the partition suit that you had mentioned. If you can come together, like we did in this case, we sat down with everybody and said, look, here's the appraised value of the property. Here's your percentage. If you want to buy out the rest of the owners, by all means do it. Here's the appraised value that's been approved by the court. Or if you can't agree, maybe 2, 3, 4 of you get together and say, let's buy out the rest. Then let's create a joint family trust. We can preserve it, for future generations. There's all kinds of options that you have outside of the court. When you go into the court system, you generally have one option. It's the court's going to look at it and say, you have multiple property owners? Yes. Everybody's a fractional owner? Yes. Can you all agree on what to do? No. What's the option? Well, you can divide it in kind, potentially, and we tried with this 70-acre parcel, but we had fractional owners that had a 1% share. Well, you can't really divide up a 70-acre parcel with 1% share. It's just impossible. And so then the next step is, well, the only other option is to have a real estate broker or a courthouse auction, which nobody wants that because that's the worst scenario possible. No offense to those that work in the court system and have it on the auctions. But having a broker, right? But if you can avoid having to go through the partition action and have the 10, 12, 15, 20 family members get together and have a joint broker at the beginning, you've now saved all those costs of having to go through a partition suit, which when in the end give you the same remedy of the property being sold and the assets being divided up. So again, all throughout the process, if you can come to agreements, that's going to be your best case scenario.
Thank you all so much for that. I really appreciate your perspectives on trying to really deal with family conflict and keep as much of this out of court as possible, and certainly retaining the estate value and being able to agree. I think many people are surprised by the fact that any owner can force a sale of that property. And as you said, it's not always practicable that we do a partition in kind where you divide the property between the owners. So ultimately, a court will try to sell that property or force a sale of the property. And I've worked on legislation at the state and federal level to ensure that rather than just a courthouse auction where the owners often get pennies on the dollar, now Florida follows what's called the Uniform Partition of Heirs Property Act, which does require a fair market valuation and a right of first refusal to those heirs to buy out the heir that is trying to sell his or her interest. So have you seen that legislation like that has made some difference in families being able to resolve these matters in a more favorable way?
Yes and no. Unfortunately. The large case that I mentioned before, all the things that the state implemented in 2020 when it adopted the Uniform Heirs Act, we were doing all those things before. Maybe in other areas of the state or around the country, you had developers that were coming in and trying to buy out ownership interests and so forth. Here we weren't having that issue, so we were getting together with the family members and saying, let's come to an agreement, let's see if we can work it out. Under the Partition Act itself, it actually allows for any of the individuals who didn't petition to have the court force the sale of the property to buy out the others. And there's a process that the court will go through. It's pretty cumbersome, actually, for the court. They've got to send notices. There's lots of different things that have to happen. I've not yet had a case where one of the other owners bought out the other interest. But we've gone through the process, and it's only kicked the can down the curb 4 months, 6 months, and it's cost more money. I know the intent is correct with the statute, but the practical reality of it is not necessarily as feasible as that. But there are ways. You know, for instance, this property that we talked about, we couldn't divide it up in a way that could allow that property to stay in the family. My 93-year-old client at the time, she was not going to move back out to the property. She had moved in the early 1900s into the city of Gainesville for school and everything, and so she was not, quote-unquote, a farm girl in her words. And so she didn't want to go back out to the property, and there was really nobody out there except for there was grandchildren of heirs, and they had no ownership rights in the property. They were the ones that were receiving the benefit of out at the property. So we tried the remedy of getting the owners to buy out the others. That didn't work. We tried the agreement regarding a real estate broker. That didn't work. We actually had 3 court-appointed experts go out there and figure out how we could divide up the property in such a way to preserve that property. It was not feasible, and so the court eventually appointed a real estate broker and the property was sold. Now, having said that, the beautiful aspect of it was when I was able to give my client a very, very large check from that, which she used to bless her family in many ways that she had no access to before. So that was a beautiful thing. And happy to report, we, as part of our sale of the property, we had a requirement in there that the future development of that property would be named after the family. So Buchanan Trails, which is out there just Parker Road, 122nd, is under the course of being developed right now, and it's got a beautiful Buchanan Trail. So at least there's the preserve that legacy of that family by name, and then of course, you know, you had individuals that received their funds. We also had what we refer to as in the legal world as laughing heirs. We had individuals that had no connection with this property, had not even known anything about it, and were not even blood relatives that received funds. Because in the state of Florida, if you don't have a will, You go under the intestacy rules. Well, several of the family members in that were married. They didn't have any of their own children. Their spouse had children from previous relationships and marriages, and they were all dead. So those children from previous relationships were the ones that received those funds. Not what was intended by Grandpa David Buchanan or Anderson Buchanan, but that's the reality. If you don't plan ahead, then you may have some heirs that you never would have intended to receive your funds.
That's a great point, and I'm going to ask you, Jennifer, what are some of those things that families should be thinking about before they get to this type of situation? I like to think of or decedent dies Monday, Wednesday the family is asking what next. So what are some of the ways that people can prepare to do a probate process?
Sure. So if you need to prepare a probate process and you know that your family member died without a will, so we're going to be following intestacy rules. It's important that you know who's in your family. Was the person married? If so, to whom? Does the person have children? If so, how old are they? Are they living? Are they deceased? Did they have children? So you start to work on your family tree. It's helpful to know what assets were there. So was there homestead property? Was there non-homestead property? Were there LLC interests? Was there a business? Are there bank accounts that didn't have payable on death? What kinds of things, was there insurance? What kinds of assets are there? So you're basically doing an inspection of someone for their stuff. That becomes the legal legacy, and if you don't make a plan yourself, the state of Florida has a plan, and you better hope you like your family.
I hear often from my clients, we want to avoid probate, and everybody wants to avoid probate. Is that a big deal?
Yes and no.
Okay, Jennifer, jump in there.
Sorry. Yes and no. I mean, probate sometimes just has to happen, and it's not the end of the world if it does. Ideally, we would like to be able to avoid probate because it puts the assets and the resources in the hands of the family quickly. But sometimes we forget, or we get a new asset that we didn't put a transfer on death or payable on death designation for, or we didn't put it into the trust, or we didn't do something with, and then probate is necessary. Sometimes people don't start to plan until they know that they're sick, and sometimes we simply run out of time. And so sometimes you have to go through probate. So it's not the be-all, end-all. It's not the worst thing in the world to happen, but it is expensive. You do have to pay court fees, and there are, you have to pay for certified mailings. There's expenses that come with it, but it's not the end of the world. But, you don't have the choice of where you want things to go. And so stepchildren aren't recognized. So there's a lot of planning that you should do ahead of time, but when you're doing it post-mortem, that's how it has to be.
So, Adam, can you piggyback here? What are some of those documents that you need to see very early in that probate process to get things started? What should families kind of be preserving and looking out to have when they come into your office for that first visit?
Sure. Well, let's speak first as it relates to real property, and what we're going to look at is the deed of record, right? So that's going to be the first step we're going to look at is, okay, who has title to the property itself? And if it was just your dad that passed away and his wife predeceased, and there's 3 children, and he has a will that says the 3 children, that can likely be done by what's called a summary probate. It's a much more condensed, quicker version of probate. You don't have to get a personal representative appointed. If it's the only asset that you got to transfer, you can go through the process and get an order of summary administration and an order of homestead to transfer that asset. But in the 3-6 months, depending on how long ago your father passed away, that property is essentially tied up. So there's nothing that you can really do until that title is put into the name of the individual. So certainly the deed of record, original death certificate, and there's 2 forms, long form, short form. The long form has cause of death and social security number. The short form has the cause of death redacted and usually most of the social security number redacted. The attorney is going to need one of both. The filing with the court will just be the short form, but you'll need the social security number for the attorney itself. If there was a last will and testament that planned things ahead of time, if there was a trust that was created, certainly those would be documents that you would look at. If you're dealing with multiple family members who are listed in a will, the addresses, the phone numbers, the email addresses of those individuals, those are all helpful information, because the quicker and the less time that your attorney has to spend on things, the cheaper it'll be for you. So the more that you can prepare ahead of time and have those kind of records and information available would be great. Certainly, depending on the type of probate, you may have to bring in copies of, creditor statements. If there's a credit card bill or a medical bill or other things like that, those would be other things that the attorney would typically look at.
We have about 5 to 6 minutes left in our panel discussion, and I really want to spend the remainder of the time talking a little bit about some of the estate planning, because I know people may have questions about whether I should have a will or a trust or, the ladybird deed. I'm getting questions about from many of my clients. So I really want to talk a little bit about some of the estate planning strategies that you would recommend for people today. And I know at the end of our session, we're going to have a full Q&A with some of our representatives here today. So if you have burning questions, save those questions, and after we complete the session, we'll be available to answer some of those one-on-one questions. But let's talk a little bit about some of the estate planning tools. A will or trust? How do you make that decision?
It depends. That was my magic 8 ball. If you didn't know what that was my magic 8 ball. It depends. And sometimes both. It just, as I said, it depends. But I think everybody needs a will.
Yeah, I think when we sit down with clients, we don't do a cookie cutter approach. Everybody has unique circumstances and unique situations in their family. If you have significant disabilities in your family and you want to preserve, assets from and disqualifying you from Medicaid or other types of government benefits, you want to plan ahead for those types of things. If you have a son or a daughter that, for whatever upbringing you gave them, the perfect upbringing, they still can't get their life together, and they've got creditor issues, or they've got divorce issues, or they've got, substance abuse issues, or gambling, whatever it might be, you might want to plan ahead for those types of situations. And so coming in and sitting down with an attorney, you're going to say, okay, look, this is what I have, this is what my goals are, this is what my interests are. I really want to provide for my church. I tithe during my life, but I want to provide a legacy for my church. I'm sure your pastors would appreciate that as well. But there are a whole host of things that you could do. We have people that will come in and say, look, I've had this horse for 5 years, and I want to provide a trust that sets aside money for my pets. There's a whole host of things that can be done. But if you just try to go to Home Depot and get the form box, you're going to get what you paid for, right? If you try to go on AI and think that AI is going to be your attorney, you're going to get what you pay for. But if you sit down with an attorney, they can look at your whole picture, your whole interest, what your goals are, and tailor it to exactly what you'd like to do. Because the last thing you want to do is do something and it doesn't meet your wishes, and then the default is the state rules, and the state rules don't always get exactly what you would want to have happen. So meet with an attorney.
All right, let's do one final wrap up. Give us one of your best recommendations, really in 30 seconds, to the audience.
The best 30-second recommendation that I can make to you is to talk to your family and make a plan.
Adam?
If you don't plan now, the attorney will become a beneficiary of your estate. And if you want to go that route and you don't care at that point, that's fine. There's plenty of attorneys that can, that can take care of that work for you. But if you want to plan ahead and you want to do things right and you want to meet your wishes and your interests, and you don't necessarily trust the government or other people to do what it is that you want, you plan ahead. And certainly when it comes to heirs property and the other things, the longer you wait, the more you're kicking that can down the curb, the more problems you're creating and the more expensive it's going to be. And so we'd rather take care of those issues up front and preserve your legacy at the front end rather than dealing with it at the back end.
Awesome. Great advice. Let's give our panelists a great round of applause. And we're going to keep this moving right along. At this time, I'd like to invite the Alachua County Property Appraiser to come forward and give a presentation.
Thank you. My name is Lali Gomez Roberts, and I work for the Alachua County Property Appraiser's Office. I oversee our public service or tax exemptions in our investigations unit in-house. And I'm here to talk to you about one of the main concerns that a lot of the attorneys that have either been on the panel or Ms. Monica Range has brought up. It is the qualification for your homestead tax exemption. So I know some of you have either inherited property or currently own property in Alachua County. How many of you have homestead exemption on that property right now? Raise your hand. Great. How many of you own the property by yourself with that homestead exemption? All of you that have your hands raised, 100% of you will have a reset of that homestead exemption once you pass away, which means whoever's going to inherit that house, your son, your daughter, your niece, your grandchild, their taxes will go up. So this is very important that we go over, that way we know what to expect during the state plan process or what's going to happen after, we're no longer here for our family members. So what's the current homestead exemption structure? Homestead exemption, it is a tax deduction on your primary residence in which you reside. You make it your permanent residence, and you've maintained that exemption. It renews automatically every year. We all know that. But one key part for state planning to know about homestead exemption, that homestead exemption is an individual exemption. So what does that mean? It means that once you file, the individual who files for it, that is the person who is entitled to that homestead exemption, to that tax exemption, and any other related exemptions attached to it. When the property owner passes away, there's only one other person who can inherit that exemption. So there's two exceptions to it. One, a surviving spouse. If there's a surviving spouse, they may continue the original tax exemption, or any minor children. Those are the only two types of exemption. That's why everybody who raised your hands, who owns the property, that's why I said 100% of that tax break, it's gonna go away. Because if you don't have a surviving spouse, or you don't have a minor child, there's nobody to inherit that exemption. Now, after a property owner passes away, what do the heirs need to do? Well, we talked about the fact that you got to figure out which one is your most disciplined child out of the group, and make sure it's somebody who is going to take care of everything from A through C. How many of you know that you receive your annual renewal receipt cards? Your homestead, there we go. Don't throw those away. Keep those somewhere, please. Have that discussion with your children about you have tax exemptions on the property. Because one of the main things that they might want to do is notify the property appraiser once you have passed away. When they're trying to clear up a lot of your documentation and a lot of your things, that's one of the concerning parts, that they must notify our office. Why? Because we have to remove those exemptions out. The reason we say that, it's because when a homestead exemption is left in place, that homestead exemption, the state of Florida allows for any property owner in all the counties in the state of Florida to be able to recoup the taxes that were not paid, the taxes that were exempted. We're not just talking about the taxes that were attributed to the 50,000 plus homestead exemption, but we're also talking about the taxes that were saved on what is called the Saver Homes Cap, that 3% differential between your market and your assessment. And it is recouped through a process that's called a property tax exemption lien. It is a very harsh word, and the way that it's described does not make it any better, because it says that whoever was receiving that exemption was receiving it illegally, which technically that's the legal part of the word. Tax liens, exemption-wise, they're identified by the property appraiser primarily, and that's what we want to avoid. We don't want the property appraiser. You don't want us to be the ones finding it. You want to bring it to our attention. The reason I say that is because a lot of the times when we find it, it's several years down the line. Several years down the line. And that creates a problem. Liens are not just, well, you save $400, $500 off of taxes. Some of these properties, if you've owned them for several years, we're talking about thousands of dollars every single year, $3,000, $4,000 that exemption saves you, which means that the process carries a 50% penalty and a 15% interest on a per year basis. So an exemption and a tax lien can drive you all the way out of your house. I'm not putting an amount, I'm just gonna say it could drive you out of your house. Especially when you have a group of people who own it and nobody wants to pay the taxes. Now it's a big problem. Now, one thing that I like to let you all know is that property tax liens that are derived through this process are considered dormant liens, which means if we do identify it, unfortunately, it is not gonna go ahead and generate a tax deed sale through math group. Nobody can go ahead and try to move on the sale of that property to a tax deed sale because they're not considered, they're considered tax liens, not, you're not short, you just did not pay your taxes, you're just short on the taxes that you already paid. Heirs do get notified 30 days after the tax lien. We're having an intent to file, so there will be a notification sent. Now, this is another thing, make sure that the mailing address on record is correct, because that's where all of our mail is gonna go. That it's where proposed tax notices will go, that's where the tax collector will also send you the bill. So that's another thing, make sure that very diligent child that you have has looked at the mailing address and possibly maybe try to get stuff mailed to their address if somebody else is gonna be on the property. So that's another thing that we always like to let you know. A lot of people wonder what happens to the property taxes as this probate is ongoing. Main thing that happens, the property taxes will be issued without any tax breaks until the probate is actually finalized and terminated. That's the first thing I like to tell everybody. Okay? The taxes on that property will be issued without any exemption. Whoever's gonna be living on that house, I do encourage you to come forward and file for the exemption. That's another thing. The reason I say that it's because once probate is finalized, whoever filed for that original application or office, by law, it's able to go back and revisit that application, as long as it's what we call a good standing application. What does that mean? It means that the only thing pending on that application was ownership. The exemption will be removed, taxes will be issued without any exemption. You come back into the office once probate is finalized. You let us know, hey, I finalized probate, put my exemption back. Why do we have to wait until probate is finalized? The same thing everybody has done in this presentation. The property appraiser, as long as your property is under cloudy title, we don't know how much exemption we can give you because we don't know what percentage of the property you own. So the application will be held, and then we can do tax roll corrections. We can refund the excess taxes that were paid, and process current tax years and put the exemption for the current year on record. Any questions? No?
Got a question? Great question. And if you don't mind, we'd like to address all of the questions at the end. So if you'll just hold that question, I promise we will answer it. Okay, at this time, we will have a presentation from the tax collector's office.
Good evening, everyone. Excuse me. Let's see here. That's just it's better. There we go. Is that it? There we go. All right. My name's Matt Geiger. I represent the Honorable John Power, tax collector. He's our elected official, and just greetings from John tonight, and thank you for allowing us to be here, and thank you, Honorable Solomon, for making this happen. This is one of the greatest events I think we could do for our community, so it's just wonderful to be a part of that. But I do want to talk a little bit about property taxes and how that interacts with these heir properties. So it was said earlier there was about 1,600 heir properties in our county. And so I put approximately 1,700, but there's a lot. And so of those heir properties, 670 of those have delinquent taxes. And that's where, the family members haven't paid. And so so they could be in danger of being sold. I just want to say something. Your property is really valuable. Your Alachua County property is very valuable. And there are investors out there that understand that, and they're going to try to get your property. And so we want to do everything we can to prevent that from happening. And that's what this is about, part of what this is about today. We had a situation where there was 39 acres some years ago. It was owned by 3 siblings, or it was in their parents' names who had passed. They never probated it. They owed $10,000 in taxes. After several years and going through bankruptcy and trying to take care of it that way, which was not a bad idea. But anyway, they got kicked out of the bankruptcy. Anyway, their property ended up getting sold. It sold for about $90,000. So each one of those children got about $25,000. That owner the next year sold that property for almost $700,000. It was 39 acres. So your property is valuable. And so don't lose it for some taxes. So that's not good. And we want to try to get the taxes as low as possible. And the best way to do that is get your exemptions and get those benefits. So last year we sold 51 properties for taxes. 19 of those were heir properties. So close to 40% of those were heir properties. So that's a very low number of properties. We have about 100,000 properties in Alachua County. We only sold about 50. So that we're happy about that. Our job is not to sell property. Our job is to collect taxes. So our goal is to get that number as low as possible. Okay. Just got a few questions, frequently asked questions we'll go over real quickly. Can I see if taxes are paid or unpaid on a property? And you can. All that information is public information. It's online. You can call our office. That's all public, and we can share that information with you. We talked about that, the number of heir properties. How long can taxes be unpaid before the property is in danger of being sold? And so if this past year was 2025, those taxes came due in November. If you don't pay those, they go delinquent the next April 1st, 2026. You've got 2 years from the date of delinquency. So if you didn't pay your 2025 taxes, April 1st of 2028, now your property is in danger of going to sale. And so you've got a couple of years. So Florida does have a pretty good system of giving you some time, but 2 years can go by quickly. And the longer you wait, the more taxes that are due. So call our office and we'll help you navigate through that and help you try to get these taxes paid. Okay. A couple more questions. If I pay the taxes, can I own the property? So you cannot own property by just paying taxes. And so, that answer is no. You have to purchase the property at a tax deed sale and be by being the highest bidder if property is going to sale for unpaid taxes. So you just don't want to pay somebody's taxes. They will appreciate it, but that won't help you at all, so don't do that. How can I purchase property? How can I purchase the tax certificate on a property? So tax certificates are sold online during the month of May, and it finalizes on June 1st every year through our office. There's a website, you can see that, but just contact the Alachua County Tax Collector's Office if you're wanting to buy tax certificates, and we can help you navigate through that and determine what's best. So the certificates are awarded on June the 1st every year by whoever bids the lowest interest rate. So when you buy a certificate, you're not buying the property, you're buying a lien on the property. And it is a first lien, and it trumps every other lien, so it's a first lien on the property. And that can be used 2 years later as a vehicle to force the property to public auction. In some situations, that can be used to clear title. And we've had heirs use the tax deed process to do that, but you risk losing the property at an auction. So I don't necessarily recommend that these days and times. We had live sales, and you could say, hey, don't bid against me, this is my grandfather's property, and people would let you have it, but they don't do that anymore. So, all right. If I purchase a tax certificate, how can I become the owner of the property? So after your certificate is 22 months old, you can apply for the tax deed and force the property to public auction. It costs about $1,000 in fees to do that, plus the taxes and interest. And so then it goes to public auction, it goes to the highest bidder. And all that's done, those auctions are processed through the Alachua County Clerk of Court. So you'll see tax deed sales at the Clerk of the Court's office, and that's where that's done. So one more slide. I did that. So this is just our delinquent tax timeline. Just November 1st is when taxes are due and payable. April 1st of the following year, the taxes become delinquent. June 1st of the following year, we sell a tax certificate. 2 years later, if the taxes haven't been paid, the property can be sold at a public auction. And so, again, that's not our goal to do that. We want to prevent that. So just remember that you have valuable property, and we're going to do everything we can to help you keep it. Taxes are a big burden, so there's ways to reduce those taxes as well. So we'll help you do that as well if we can. Thank you.
Thank you so much. You've heard already from some of the private attorneys in your community, and now we want to introduce one of our public partners who provides legal services through Three Rivers Legal Services, and you can hear more about how you can get free legal services in your community.
Thank you, Monica. Appreciate it so much. Hi, my name is Diana Johnson. I'm here from Three Rivers Legal Services. I'm a senior staff attorney there, where we offer legal services such as probate and estate planning, like we have been talking about tonight, to our low-income members of our community at low or no cost. Some of the things that we provide that are relevant to what we're talking about tonight is probate. So we've talked a little bit about probate, and I'll give a general definition. I know we're going to talk about it in the Q&A. But probate is the process that happens after you pass away so that your assets are distributed to your heirs. So that's one of your loved ones is going to go directly to the court or talk to an attorney and say, hey, this loved one has passed away. These are all the things that they owned. These are all the members of our family, and we're looking to clear title to that property. That's sort of like a short summary of what probate is. There's two different kinds, which they did touch on during the panel discussion. There's a summary administration, which is a shorter process for smaller estates that usually it can take as little as like 4 to 6 weeks. So it doesn't have to be a very complicated, intimidating process, especially if the person passed away a long time ago. You can do that short, easier version of probate. Formal administration is the longer version of probate that we usually move forward with if someone passed away fewer than 2 years ago. That is a lengthier process that can take, at minimum 6 months. I would say 6 months if everything goes very smoothly, but it can often take longer, 8 to 12 months maybe, depending on what hiccups come up along the way. So what we want is for things to move forward very smoothly for your family to avoid the probate process so that your property does not get tangled up, like it was up here with Monica, with the string, okay? That's my job, is to untangle that big mass of people with the string. That's what I do a lot. And to prevent it from getting tangled in the first place. So how do we prevent it from getting tangled in the first place? We do estate planning, right? And again, estate planning, nobody really wants to talk about what happens when you pass away, but I want to talk about it because it's important. This is preserving your family's legacy, okay? And it doesn't have to be an intimidating process. It can be a simple process, and we can always talk about it. So, you know, having a last will and testament. I know I heard Jennifer say that she thinks everybody should have a will. I agree with that. I think it's great to have a will. A will does not prevent probate, which is a common misconception, but the will tells your family what will happen in the court process for probate. The will says, I have like 20 family members, 20 heirs, but I want this one heir to get my house, to keep title clear and simple. That's what you can do with the will, is to keep things very simple. So you still have to go to probate, but it can make it a much easier process. To avoid probate entirely on your property, you can do what's called a ladybird deed. This is a service that we offer. That's a new deed for your property that says, I own my property for the rest of my life, and I can still do whatever I want with my property. But if I still own this property when I pass away, I want it to go to this person. It's like naming a beneficiary on your property, and then you pass away, that person shows your death certificate, and then automatically that title transfers to that person. Ladybird deed is like the gold standard for us. We really want to do these ladybird deeds for your property to prevent it from going to probate, prevent that title from getting cloudy. I will note, if you have minor children, let's talk about it a little bit more. You cannot usually do a ladybird deed if you have minor children. But ask me questions about it at the Q&A, because I'll talk about it more. We also offer advanced directives to all qualifying people that come into our firm. Advanced directives being a durable power of attorney. It's where you're naming someone to make decisions for you in the event that you are unable to make them for yourself for your finances. That's signing documents on your behalf, managing your finances, and making sure all your bills get paid if you're not able to take care of those things. Also, a designation of healthcare surrogate. That's a document where you're saying, if I'm not able to make my own medical decisions, this is the person that I want to make my medical decisions. If you do not have that document, your doctor is going to look automatically to your next of kin, which might not be who you want to make those medical decisions for you. Say you're legally married, but you're estranged from your spouse for the past 20 years. You don't want your spouse to be the one that's making decisions for you. So that allows you to make a choice as to who's making those decisions. And then a living will, which is where you're going to say what your wishes are regarding end-of-life care in the event that you are incapacitated by a terminal condition or an end-stage condition or a vegetative state. That's when you say, if I'm hooked up to a ventilator, I don't want to live that way. Or maybe you do. There is the option to say, please keep me alive at all costs. And we do have options for that as well, just to make sure that your wishes are honored. But the typical is that we would want to be removed from those measures, but we have options for you. So I'm definitely going to answer your questions at Q&A, sir. I do see you back there. I'm not ignoring you. But we offer those advanced directives. I think everyone should have those documents. They're so important, and we could talk about a will as well. So what does it take to qualify for services at Three Rivers Legal Services? We typically offer services to the low-income members of our community, and we define that as at or below 200% of the poverty level. So I have a little table up here. I know it's really small. I can show it to you in bigger form on my phone if you want to talk about it later. But it shows that it goes by household size. So if you have a household of one, there's the gross yearly income for a household of one. I can't even read it, actually. 31,920. Thank you so much, Jennifer. So if you have a household of one, you're looking at $31,000 per year or less, and then it goes up with each household member. That's how we would determine whether you qualify. There are some asset limits as well. It's usually $8,000 in assets, not counting your homestead or your vehicle. So but I encourage you to apply anyway. Because we can always try to see if we have funding available. We have a lot of different grants with different requirements, and we really want to provide these services to the members of our community. As far as the intake process goes, you can call and apply at the phone number that's listed there. I have brochures out here that have our phone number on them. And then you can also apply online at trls.org. I also have applications that are in your folders that you received in your bags. If you want to fill out an application and give it to me, I can provide it to our intake team and somebody will call you. So we screen your application to make sure that you're eligible for our services, get it entered into the system, and then you'll usually get a phone call from our intake team to schedule like an interview to give information before you get passed on to an attorney. We do have a larger wait list. Sometimes it can take a few months for us to get to your case, so please don't lose hope in us. And we actually have a new attorney that's going to be starting with our firm for this area. So we'll have 3 attorneys total, myself and 2 other people to provide services to y'all. So please apply. I would love to see you and talk to you about it. I think that's all I have. Okay, we have the wait list. Emergency cases are given priority. If something's going on, there's a pending, the tax sale is imminent, or you're having extreme health issues, we will try to move you up. Like, I get those calls all the time. I'm like, I'll do it for you today. I'll do it right now. If you call me, I will try to work it out for you if you have some extreme circumstances. Thank you, everybody. I really appreciate it. And I look forward to hearing from you at Three Rivers Legal Services. Thank you.
Excellent. I know we have a few burning questions in the audience, so we do want to get to that Q&A and have all of our presenters come back up for the Q&A. But before we do that, I'm going to invite your property appraiser, Ms. Aisha Solomon, back to the podium to give us some words about another collaborative partner, the Federation of Southern Cooperatives, and do some closeout comments, and then we'll move right into our Q&A.
And I don't want to stand in between that because I know there's some burning questions. I can feel it on the back of my neck. All right, before we move forward, I would like to take a moment to recognize one of our important partners. That's the Federation of Southern Cooperatives Land Assistance Fund. Okay. Unfortunately, representatives from the Federation are unable to be with us today, so I want to share some information about the resources that they provide. The Federation work is centered around helping families preserve generational land ownership. They provide legal, educational, and financial resources designed to help families protect inherited property, preserve their land, and build legacy for future generations. As you can see on the slide, their services include heir property assistance, estate planning resources, legal mediation services, land retention support, and their heir property lending program. So we sincerely thank the Federations for being a community partner with us and sharing this work. Before we open the floor for questions, I want to remind you that tonight is step 1. Our goal is to help you take the time to learn what has been applied tonight and put it into action. You have information about the workshop in your folders, and you can also register on your way out this evening. Our free probate and estate planning workshop will be held Saturday, September 26th from 10 a.m. to 4 p.m. right here in Greater Bethel AME Church. The doors will open at 9 o'clock. We also have a legal network directories available, and I thought they were in your folders, but they're not. The attorneys that are participating on the panel tonight, please feel free to pick up a copy on your way out for additional resources. At this time, I would like to provide or to invite Monica and all of our presenters back to the stage for our general Q&A, and we will also address questions from our live stream audience as well as time allows. If you have any questions and you're able to do so, let's begin lining up one at a time at a designated microphone at this time. So the microphones are here. And I'm going to invite Monica back up. Thank you.
Okay, so we have 2 microphones available here, or if you'd just like to stand, I've recognized the gentleman in the back. If you would like to stand and give us your question. And we may be able to get a microphone there if we can float one microphone there. I think I see one coming.
You mentioned a lot about probate as if everybody knows what that means, but nobody has defined what it is, going to probate. Why do you what was the situation where you would go to probate? So that's why I was concerned, because nobody has really defined it. So that's what I want.
Thank you for that question. That's a very valid point. Can you hear me okay? Perfect. Okay, so probate is simply the court-supervised process of distributing assets. So creditors are paid, and after creditors are paid, everything goes either to the beneficiaries that are designated in a last will and testament, or it goes to the intestate heirs. So that's what probate is, very simply. It's a court-supervised process of distributing assets. And so if you have a will, the will needs to be deposited at the clerk of court, and a certified copy of the death certificate. That starts the probate process if there were not things that transferred automatically. If there is no will, then it goes through the intestate probate process. Intestate is when you do not have a will, and the state of Florida has a process that for determination of how your stuff is divided up.
And as it relates to real property, for instance, individual passes away, the property is in the name of that deceased person. In the court process, there will be orders that are entered that indicate who those beneficiaries are. It could be either an order of homestead, if it was a homestead property, or an order of summary administration, or the personal representative changes and issues a new deed transferring that into the name of the beneficiaries, or perhaps the property is sold. But it's simply changing the title from the deceased person into the name of the beneficiary or the buyer.
Other questions?
My question is, could I go out and get another deed and make a will for someone else, but I would own property?
Can you say your question again, please, sir?
I already own property myself, right? Could I go out and get another deed and make a will for someone else?
So I believe the question was that you already own your property in your own name, and you're looking to get a new deed and to get a will. Is that correct?
A will for someone else.
Yeah, that's correct. So you are able to do that. If you're looking for a private attorney, we do have some great options right here. And you can also apply for services at Three Rivers Legal Services. We offer wills to anyone who owns real property in our service area.
Okay,
And we could talk about a deed as well.
thank you.
I just wanted to add that there are different kinds of deeds, and so you want to be careful that you don't just use AI or do something weird. You want to make sure that you have the right deed for what you want to accomplish, so that should have a follow-up conversation.
And with that as well, let's say, for instance, you were deciding, look, I want my property to go to this person, right? You could just quit claim deed that to that person right now, but then you don't pass for 10 years. Right? If you were to transfer that property now, that increase over the next 10 years is that person may have some tax liability for that 10-year gain. Whereas if, for instance, the Ladybird deed, which the representative from Three Rivers mentioned, is a way of you basically saying, I'm going to deed it to this person, but I still have the right to sell it, rent it, do whatever I want during my life. But when I die, that property goes to that person. Well, now you've saved that 10 years. So they don't start their process of their valuation until you pass away. So again, there's trust deeds, there's Ladybird deeds, there's just general quitclaim deeds. There's lots of different types. And so it's important to have the advice of an attorney that can walk you through to make sure that it's exactly what you want.
Kind of to chime in into that, and that's the administration part of the tax exemption purpose. Have a very clear conversation with the attorney that you're gonna, take to do this type of deed, because if you are still alive and this continues to be your permanent residence, and you've had a homestead exemption for the purpose of lowering your taxes and maintaining those taxes at a lower rate, Any title transaction that you do could affect your homestead tax exemption. So make sure you have a clear conversation. Let them know this is still going to be my home. I want to continue my homestead exemption. Make sure that any title transaction you do is not going to affect my homestead status. Because let's say you don't have that conversation and you don't say that, and you just say, I want to share title with so-and-so, so if I die, they're going to get the property. It might happen that way, but the way it's going to happen is that you might just end up owning 50-50 with that person. It means the homestead you had now needs to be cut in half. So that might be, that's why I said make sure that when you do that, or if you go into a trust, make sure it has the trust language to keep the homestead exemption and things like that.
Yeah, the magic language. Don't do it yourself, folks. Please don't. Please don't get forms online. They're usually not good, and you're going to do something you don't want to. So always talk to an attorney about it, please.
She might have already answered the question, but this is about the homestead exempt. If a person, it's an heir property, if a person been living there about 5 years or so, so it's okay for that person to live there, have no place to go. So can they file for exempt, or it have to be in their name? The house have to be in their name?
My answer every single time I get this is, if it's your permanent residence and you are an heir and you're residing there, even if property has not been distributed to you, file your application. What happens is this: the statute for refunds does not take effect unless there's an application on file with the property appraiser's office. If there's no application, we don't have jurisdiction to submit your request of refund of taxes to the Department of Revenue to give you back excess taxes paid once probate finalizes and tells the property appraiser, hey, she owns 50%, 20%, or owns everything outright. That's the issue. So yes, I always encourage, file an application. We will hold it on our records. We have a 10-year record retention. So whenever probate finalizes, just come back. We'll look at that application. If it was a good standing application, we'll process refunds for 3 years and current. That means 4 years in total.
Oh, okay then. All right then. Thank you.
But you do have to file probate if it's not in your name yet. So just to be clear, it's not just applying at the property appraiser's office. You have to also do probate, because that's the mechanism that will transfer ownership from the deceased person to you. And then you can get benefit of that retroactive to when you applied.
Correct.
Can I get homestead exemption without going through probate?
You cannot. Well, I mean, homestead exemption, correct me if I'm wrong, Lily, is you have to own the property and you have to reside in the property. Those are like the two things you need to get homestead exemption.
I do.
So, then you can get homestead, you can just apply for it.
Yes, the
But
fundamental.
it got cut off and I don't understand.
So the fundamental requirements for homestead is, first, you have to own the property as of January 1 of the year of application. A lot of the issues that goes back to heir properties is that because you've resided there, you think that you're going to inherit, or that exemption is going to continue under your name. And that's the problem. That's why sometimes the exemption ceases to exist on a parcel, on a property, and it's because whoever used to have the exemption, whoever used to own that exemption, has passed away, and that exemption is non-transferable. It cannot be transferred to anybody else other than a surviving spouse or a minor child. So you can submit your application, you gotta make sure it gets approved though. That's the other part.
Well, will a quick claim help?
Is it heirs? It's who owns your property right now?
I live in my father's house.
But who is the legal owner on title? When we send you notifications, the ownership, how does it reflect? Does it reflect an heirs?
It's heirs property.
So this is the problem. If it reflects an heir, it's a cloudy title, which means you can submit an application but we're not going to be able to process because we don't know how much of that property you own. So what happens is this, exemptions wise, they are applied in a distributive manner, which means if you own 25%, only 25% of the property is going to be exempted. If you own 100%, it's going to be exempted at 100%. If you own 80%, and so forth. We cannot divide that exemption or apply that exemption properly. It's an administrative issue because we don't know how much of the property you own. That's why, yes, you do have to probate the property in order to determine how much you own of the property to apply the exemption to it.
So I just want to make sure that what you said was this gentleman would need to open a probate, and there are resources, sir, tonight that can help you get that probate started. So potentially Three Rivers is one of those resources, and we have 2 private attorneys here who can also talk with you about how to get the probate started so that you can maximize the amount of the homestead exemption you actually qualify for.
And make sure you have an already filed application that is considered good standing other than the ownership issue.
Where is our microphone? Okay, and I see we have a question in the front as well, so I'm going to bring you a microphone too, but we'll take your question in the back.
Thank you. My concern is the trust. How advantageous is it, or does it help us with that probate process?
A trust is a more complex estate planning tool that can be really advantageous depending on what your goals are. For example, if you want to leave a lot of property to minors and you want to have a little bit more control over how that property is inherited, you can place it in trust for it to be inherited by, younger people with someone else that has authority over that property until they're old enough to manage it. Or if you have loved ones that have special needs and you're trying to make sure that their benefits are preserved, a trust can help you do those types of things. If you have a simpler estate, you have some bank accounts, you have a house, you might not necessarily need or benefit from a trust, but it certainly is always an option. It just depends on what your goals are, and you would need to talk to an attorney about it to determine what path is best for you. Do you want to speak?
Sure. It used to be that everybody thought they needed a trust, and then the Lady Bird deed came about, and we're like, okay, not everybody needs a trust. A trust gives you control over how assets are spent during your life. So if you're the original grantor, you are also, and if you're also the beneficiary, you can control it during your lifetime. And you can say that, how you want things to happen and if you should become incapacitated. And so you can say, this is how I want my funds to be spent. On me first, then on my dependents. And then once you're deceased, you can then say, these are things that I would like to have happen for these specific people and these specific charities, and this is how I would like it to be done. And so you can have guardrails that say how you want your beneficiaries to be able to use the property and to be able to use resources. And so it gives you control beyond the grave, depending on how much control you think you need. Some people want to wait till their kids are in their 60s and 70s. I kind of try to caution about that. If you have someone who has mental health issues, or you have someone who has creditor issues, like Adam was saying earlier, there are a lot of reasons to do a trust, and there's also a lot of reasons to not do a trust. So each person's circumstance is different, and it just depends. I refer to trusts as providing guardrails, so that you don't have a young adult getting a big sum of money that they're not equipped to handle yet because their frontal lobe isn't fully developed. Oh gosh, yes. A trust is absolutely worthless if you don't transfer property to it. So if you're going to transfer real property to it, you need to do a deed to trust. If you're going to do a bank account as a to be the trust to be the beneficiary, list the name of your trust. You'll have a certificate of trust that you present to the bank. Life insurance, same way. I'm not going to get any further into qualified plans. Go ahead.
So, and I would just think of it this way. Most people are familiar with a last will and testament. That's where you name who my beneficiaries are, who I want in charge of going through the court process. A trust is something that you do where you're naming beneficiaries, you're naming who you want in charge of it. Instead of a personal representative, it's referred to as a trustee. And you bypass the court system. So that's one of the benefits of having a trust created versus a last will and testament that goes through the court process. And then, as mentioned, you transfer assets to the trust. And so the gentleman asked about a deed. Well, if he had a trust created, he would sign the deed himself individually if he's single, to himself as trustee of the such and such trust, and then the trust becomes the owner of that property. But again, you got to be cautious, because if you don't have particular language in the trust and in the deed itself and in your cover letter to the county clerk or appraiser's office, so forth, you want to make sure you're preserving your homestead tax exemptions that are part of it. It's just, at the very beginning, Monica had the basket of tools, right? A will is a tool. A ladybird deed is a tool. A trust is a tool. Not every tool works best for everybody. So have an attorney review it, figure out what's best for you and your own individual circumstances, and maybe a trust is viable, maybe it's not.
I have a question back here. Oh, you have one there first? Okay.
I have a question about Heirs property. There's 6 of sibling. Everybody live away. I have one sibling living here, but she refused to sign. She refused to sign anything for my parents' property. She don't want to do anything to it. She don't want it to be nothing. Is there a law that can help me say that because someone refuses to sign? Do that stop me? Can I do anything?
So the property has not gone through probate, and she's refusing to take any action. Is that what you're saying?
Secured in my name.
Okay. Well, I mean, as far as the probate process goes, she doesn't necessarily need to sign anything. She would just receive service of what's going on. Like, she would receive the court documents, and then she'd have the opportunity to potentially object. But if she doesn't object, she doesn't have to sign anything. She doesn't have to take any action for you to clear the title. And for you to get it in your name, though, she would have to sign it over to you, which you can't really force her to do. Who owns it currently?
To receive something from the court, you said?
So who owns the property currently?
No one owns the property now. It's Heirs property.
It's Heirs property. Yeah, so you have to do a probate.
Get it, but every time I try to get it, she refused to sign anything.
Yeah. So you can start the probate on your own. She doesn't need to sign anything. She would receive service. She would get the court documents in the mail as long as you have her address.
She would get invited to court to participate in the probate.
Oh, okay. But she doesn't have to.
She doesn't get to participate.
Correct. Mm-hmm. And then if you're trying to get the property in your name after the probate is complete, that's a stickier situation because you can't force her to sign it over, but you can force sale of the property, which I think Adam was talking about earlier. Does that answer your question?
I think that
I just want to know, can her not sign stop me from doing
I think maybe your particular issue has a lot of facts to it, and it might be something that we would be able to answer individually. We don't want to air everything in front of everybody. We want to respect your privacy some, because we want to understand what forms you've tried to have her sign and stuff. So I would say that's a private conversation that we'll absolutely be able to help you with, either Three Rivers, Adam, or me. Adam's definitely more of the partition guy than I am.
We try everything before we go through the process.
But just so you are aware, anything that you might want her to sign right now, because the property's in heirs, either you or her, you really can't sign anything at the moment because nobody owns the property until the probate is open and finalized.
And let me just say, as a little bit of a disclaimer, this is legal information that we're providing tonight because some of these situations are very specific. So we want you to follow up. We want you to attend the next session that Ms. Solomon advertised in September that will be more one-on-one assistance to answer some of your questions. So let's go here, and I have a person waiting in the back as well.
So I actually have 2 questions. I promise they're real short, though. So the first one is, when properties are sold, because that was how I cleared one of our property situation, we just let it went to the tax deed sale. Thank God we were able to outbid. Who gets that money? Where does that money go?
So when a property is sold for taxes, the opening bid includes all the taxes and interest. But if it gets bid up, that's called the overbid. And that money is held first by the clerk of the court and then I think turned over to the state. But it can be, it can be claimed by the owners of the property. But if the owners are dead, you still got to do probate to get that money. So I saw a situation though where there was like $13,000 and the attorney allowed the one single heir, was a sole heir, they ran it through the probate. She took the proceeds out of that money, that overbid money, to pay for it. The attorney worked really well with the person, and the person got about $12,000 out of it. So it was a great, the attorney worked with that client to use that overbid money to actually fund the probate work. So
to be clear, property, just say property worth $10,000, but it sells for $20,000. They're gonna finagle it all through that. By the time I pay for all attorney, it's gone anyway, right? Okay. So the second question is, so I have no children, have a little bit of real estate going on, and I'm considering doing a trust because I want to go ahead and have things done. But in going through my properties, I noticed some of them are quick claim deeds and some are warranty deeds. How does that affect, will it cause any issues later? That makes me a little nervous. Thank you.
It depends. Unfortunately, that is the answer, right? So, and just as a general understanding, there are different types of deeds that do different things. A quit claim deed basically says, I'm giving you whatever I have. I'm not saying I have anything, but whatever I have, I'm giving to you. That's a quit claim deed. If you're the buyer, that's the worst thing that you want. A special warranty deed says, whatever I have while I owned the property, I'm warranting and saying that if somebody comes after me and says that I did something while I owned it, then you can go after that individual. A general warranty deed is the best one, especially as a buyer. That basically says, I'm warranting from the beginning of time that what I'm giving you is clear title. You're also, you're going to probably want to get title insurance, which is, when you're buying property, to make sure that you have a title insurance company that is guaranteeing that you have what you think you bought, right? So that if somebody comes forward later and says, I was an heir of this property and I was entitled to XYZ, or I'm a part owner of this property, then you go to your title insurance company and you say, title insurance company, I paid you a premium. I want you to defend my title, clear the issues, and avoid it. So that's where title insurance comes in. But there's different types of deeds. Oftentimes people will say quit claim deed, and they'll also refer to it as quick claim deed. There's no such thing as quick claim deed. It's just a misnomer. Quick claim is you're not saying you own anything. You're just giving whatever you have, and sometimes it's worth the paper that you have. Right. So it may be perfectly valid title. That may be there's nobody else that comes forward and claims anything other than you're the owner of the property. If you want to be sure, you can contact a title insurance company, ask them to warrant your title, basically insure your title, not warrant, I used the wrong word. Insure it to make sure that you've got what you think that you're entitled to.
Great questions. Let's take a question from the back.
Yes, thank you so much. I would like to avoid the whole process of the probate. And so I have property, and how do I transfer it to an adult child? We live in the household together, and I would transfer that property without, I've been told that I could do a TOD. I'm not waiting until I die to want to transfer it, and I can transfer it now. But then I am told that if I was to do that, there would be lots of taxes or something, to that effect. I would like to know how effectively to do that, because I think it gets really complicated when the, speaker presented to us and with the, just through the family and leaving that. how can I do that? Just get it done. And what is the most effective way to just do it now?
Well, I will start out by saying that I get this question a lot from parents because they will ask me, should I transfer my home to one of my adult children? Because if I go into a long-term care situation, I know the federal government has a 5-year look-back period. I need to get rid of my assets. And so my first question to them is, do you know your children?
Yes.
Because if you give an adult child your house, say you give them, you keep a life estate and you give them the house, that interest in the house, if they have creditors that can come after your house, you could end up homeless. So you want to be really careful about how you might transfer a home to an adult child, and then you want to know the child you're dealing with before you do that. But there are a number of ways that you could do that. I mean, you could do it outright as a deed. You could keep a life estate in that home and transfer the remainder to the adult children. You can deed it outright to them and come up with some other type of arrangement. But just be careful about that because it does open you up to any creditor claims that adult child may have. Okay. Other attorneys want to add to that?
It depends. Really, I mean, your unique circumstances, a ladybird deed may be sufficient for you. A trust may be sufficient for you. There are lots of different options that you have. So sitting down with an attorney that can walk you through what your options are and what the ramifications would be on each of them, because there may be tax liability, there may be, generation tax that, if you transfer the property outright to somebody now, but you're planning to live there and you live for another 10 years, well, now their increase is going up over that 10 years. Whereas if you did a ladybird deed or a trust deed or other things, they don't have the tax liability until the day of your death. So there are lots of different options that you have. And certainly speaking with an attorney that knows what they're doing can walk you through what those options are, what the ramifications would be.
Thank you.
And I see we are just about a little bit over time, but we want to take one or two more questions. This has been a very rich discussion, and we really appreciate all the questions. Yes?
So one of the benefits of having a trust is that it is not of public record, whereas when something goes through probate, the whole world sees exactly how the money is appropriated. My question is, you mentioned the ladybird deed. Is the ladybird deed public record? It is. Okay.
It's
Yes, the
recorded
ladybird
like
deed
any other deed.
Yeah,
Gotcha.
just recorded like any other deed in the public record, so anybody can look it up.
If you have a concern about privacy issues with real property, it's really hard because you can trace chain of title, but you could title it in the name of a trust. There are things you can do with creating an LLC. There's things you can do, but it's hard to make it so that nobody can ever find out who owned it before, because there is that chain that already exists.
Yeah, for good and bad, Florida is a very open record state, right? We can find all kinds of information that's online, which for many respects is very, very good. For privacy, not so much, right? So a trust or other things might solve that problem by keeping it private. You don't list the beneficiaries in the name of that deed. It's just transferred to the trust or the trustee of that deed, or the trustee of that property.
I think we have one more question.
Yes, I am going to just share a couple of quick questions based off of some of the chat interactions that we had on the stream. So the first one, based off of different factors such as age, financial status, and the size of the property, how would I know which estate planning option would be best for me?
It depends. I mean, everybody needs to plan for death, and everybody needs to plan for incapacity. And so the question is, how are you going to do those preparations? And that's what would be answered by your attorney who would help you walk through that process. So as Adam said earlier, there's not a one-size-fit-all for estate planning. Everybody's needs are different, everybody's income is different, everybody's goals are different. Some people are very charitably inclined and might want to create a foundation. Other people might not be charitably inclined and they want to they want to take care of their families. They want to have intergenerational wealth. You don't know. And so until they have the conversation, it's hard to tell.
Okay, yeah. The next question, what determines the length of the probate process? I feel like I know what the answer is going to be.
It depends, yeah. It depends on the complexity of the assets and how difficult it is to sort of collect those assets. Depends on how many heirs there are and how difficult the heirs are to deal with. Because if there's a large amount of heirs or you're giving complicated shares and there's minors involved, it's definitely going to be a more complex process. But if mom dies, she wasn't married, she's got 2 kids, the 2 kids get along, it can be extremely simple. So it really depends on a lot of factors.
And one of the things I want to just kind of leave with everyone is keep in mind that even when you go through a probate process, there are things that you can do to remove assets out of that probate estate. For example, your bank accounts. You heard one of the attorneys mention that if you make your bank accounts payable on death, those bank accounts will automatically pass to that beneficiary that you leave as the payable on death beneficiary. So there are things that you can do to make that probate estate smaller and limit the time that it might take to probate the estate. So bank accounts, boom, I can check those off. They all have beneficiaries. Say investment accounts, boom, I can make those transfer on death. Life insurance policies, boom, they already have named beneficiaries. So there are things that you may be able to check off that list to make your estate, the probate estate, much smaller and also decrease the time and expense of having to probate your assets.
And the likelihood that creditors will get their hands in it. So anything that passes outside of the probate process directly to a beneficiary is not technically part of the estate. So if somebody tries to make a claim on your estate, they're not going to get that money that passed directly to your kids from the bank account.
Exactly. With that, let me just ask everyone to give our panelists another big round of applause. Let me thank you for coming out to make this 10th Summit a great success. We hope that you can take all of these very valuable nuggets back, and we hope that it's inspired you to have more conversation around how you prepare to do estate planning or take your journey through probate and make sure that you are protecting the assets that you own. Thank you again to Ms. Aisha Solomon and her team for doing a phenomenal job to plan this event. Have a great evening.